Can a criminal case appeal go to the Supreme Court? Imagine facing a criminal conviction and wondering if your case can reach the highest court in the land. It's a question many defendants ask after exhausting lower court options. When someone is convicted in a trial court, they usually have the right to appeal to an intermediate appellate court. This is the first step where legal errors, like improper jury instructions or wrongly admitted evidence, can be challenged. If the appellate court agrees there was a mistake, it might reverse or modify the verdict. But what happens if the appeal is denied? The defendant can then ask the highest court in the state or the Federal Circuit Court of Appeals to review the case. This is called seeking a writ of certiorari, which is a formal request for the Supreme Court to look at the case. The Supreme Court is the top court in the United States and has the power to choose which cases it will hear. It accepts only a small number of appeals each year. The court usually looks at cases involving important constitutional questions, conflicts between different appellate courts, or issues that have a broad impact on the country. Most criminal appeals do not reach the Supreme Court. They usually end at the intermediate appellate court or the highest state court if the case does not meet the court's criteria. Filing an appeal to the Supreme Court involves submitting a petition that explains why the case is important and why the legal errors matter. This petition must clearly show how the case involves significant constitutional or legal issues. From a defense standpoint, it's essential to understand that getting a case before the Supreme Court is very rare. The process requires careful legal work and strong arguments. The attorneys must demonstrate that there was a serious legal mistake or a constitutional violation that affects the defendant's rights. They also need to show that the case has broader implications beyond just the individual. In summary, yes, a criminal case appeal can go to the Supreme Court, but only if the case involves big legal questions or conflicts in the law. It's a selective process that involves filing a petition for a writ of certiorari, and the court decides whether to hear the case based on its importance. Most appeals stay in lower courts, but when the stakes are high, the Supreme Court may step in to make a final decision.